Hello everyone, welcome to another Wednesday webinar with the Property Law Alliance. We are pre-recording today, however we will post the video to the page so you can watch it anytime you want to. And then a special welcome to Silna and Bruno.
Hi Marley.
Hi Marley.
How are you guys doing?
I'm good. It's been a good week so far.
That's
for
good.
Silna, it's going to be even better week. So
yes,
Yay.
definitely. So for all our viewers, it's Silna's birthday tomorrow. So I just want to wish you a happy birthday. I hope you have a lovely day and a lovely year ahead and get well rested. I'm so glad you took a bit of vacation for the next week and a half. So that's good. But
so all the viewers need to put as many messages in the group and on the page as possible.
Definitely.
Oh, thank you guys. You're so sweet. Yeah, that's definitely why I'm going to have an amazing week and a half. I'm taking leave and I'm basically disappearing from the face of the earth. I'm evicting myself from working for my birthday. So if I seem very quiet and gone, I promise I'm still here. I'm just not telling you guys where I am, just to get a bit of a break. But thank you so much for your wishes. It's really, really kind of you.
Oh, it's a pleasure. All right, then we can get going on the questions. We do have a few, which is great. The first is regarding an offer to purchase. So I'm going to read the whole question. There's a few questions at the end, which we can maybe just discuss briefly. We bought a residential property during lockdown. We put in an offer and special conditions clause in OTP, stating all the defects that needs repairing. And the sellers accepted the OTP by signing. It's been 5 months now. The agent has been trying to get the sellers to complete the OTP list of snags, and the purchaser is not repairing the agreed fixing list. The attorneys know about this and are trying to lodge, but say that an addendum must be signed by both parties in agreement to lodge while repairs get done. However, the seller is adamant not to repair all the snags and won't sign an addendum. The seller is stalling the transaction of lodging for 5 months by not committing to his part of the agreement. We need to be out of the premises where we are staying by end of September. If this lodgement of transfer is extended longer, we don't have a place to stay anymore. Please explain who needs to take the action. Can the transfer attorneys keep a retainer amount to cover the anticipated costs for the OTP repair jobs that still need completion in order to start with lodging ASAP? These repair costs would then be retained from the proceeds due to the seller, which amounts would be retained in the transferring attorney trust account and released once the OTP list is complete and transfer is successful. If the agent is struggling to get the seller to complete the fixing of the special conditions snag list, then shouldn't the attorneys assist? The seller is stalling the transaction. All our transfer fees are paid upfront, and we are just awaiting the seller to fix these items on the signed OTP. All right, so it's quite a long question. I don't know, Silna, if you maybe just want to get started on this one.
That's a birthday question.
Yes.
Thank you, Marley. That's the kind of gifts I love. So it's a very long question, and actually I just want to reduce the question a little bit, just summarize to get to the gist of the question. So basically what we're dealing with is there's an offer to purchase. From the question, it seems like the purchasers had special conditions about certain items that had to be fixed, and the seller then accepted that particular proposal. If I understand the question correctly, that there's actually like a recorded list of items that has to be fixed, then 100% the seller is responsible for that, and the seller then is in breach of the OTP by not attending to fixing the items, but also potentially in breach of not getting the property to transfer as quickly as possible. Because that's usually a standard provision in an offer to purchase, that the seller will do everything possible, well, both parties, everything possible and attend to all the necessary things to transfer the property. So it could be a very short and simple answer. If those items are very specifically set out in the OTP, the seller is in breach of the offer to purchase, you need to place the seller on terms. The problem is, you need to appreciate that when you place the seller on terms, or any party for that matter, you need to choose your remedy. So your remedy will either be cancellation of the offer to purchase or specific performance. If you opt for specific performance, just be very careful here, because you will only be able to get to court in, call it, about 6 months if you are lucky. So to opt for specific performance might not solve your problem. To get to cancellation at least solves your problem on this situation, unless you desperately want that particular premises, but it doesn't solve your problem on accommodation. But at least if you cancel the offer to purchase, most OTPs allow for about 7 or 14 days, at least you know where you stand, and it gives you some level of certainty. So that would be my recommendation. Go to the offer to purchase. Just make sure that it is very specific, and it is properly set out what has to be done. Then you can place the seller on terms. Unfortunately, remember, the conveyances in a transaction, the conveyance's duty is just to transfer the document, to transfer the property, so draft the documentation and then transfer the property. It's not the conveyance's obligation in any way to ensure performance by both parties. There could be responsibilities, for instance, make sure that you receive the money on trust, the purchase price, and you can't transfer without receiving the purchase price. But the obligations of conveyances are very limited in as far as it pertains to performance by both the seller and the purchaser.
Okay.
Bruno, do you have anything to add on that one?
So I've dealt with these situations quite often, and there's just one more interesting thing maybe worth considering. Now, it's a bit difficult to get this going, and especially if the seller is not cooperating. But so Silna mentioned the two remedies, which are basically the remedies in our law that we're entitled to follow: specific performance or cancellation. But there's a contractual principle, and I'm just briefly going to explain so people understand the gist of it. So when we look at reciprocation, certain terms in the contract are subject to other terms. So for example, a person needs to do something before he's able to get something else. Now, it's not a given that there's reciprocation. So in a lot of times you're forced to perform your end of the bargain, even if the other person hasn't yet performed. And when it comes to things like this, if you're looking at the repair of defects, it's not always necessarily, it doesn't necessarily go to the root of the contract every single time. So for instance, the payment of the purchase price has to be made on transfer. So that's kind of a given. Reciprocal things that actually need to take place. So if a guarantee is withdrawn before transfer is passed, one can actually withdraw it out of the deeds office, because you shouldn't be able to pass transfer if the guarantee is not in place. But something like, for example, with defects, one could always maybe consider saying, well, what is the value of the damages? Are we looking at very, very substantial amounts or minute amounts? Is this a matter of principle? Or is it something very serious? Because if it's small, let transfer pass. Now, trying to get the conveyancers to hold money in their trust account, the conveyancers won't do that. The conveyancers aren't technically allowed to do that. I know conveyancers that would try and say, well, there's a dispute over the amount, so I don't want to get involved, and they'd hold it in the trust account. But I also know conveyancers that go, listen, sorry, but give me a court order or I'm paying it out. But that's the answer to the problem. So if the amount is minute, consider suing the person later out of small claims court. If the amount is a little bit bigger, you could always go after some form of interdict or court order, something very light in the process now, just asking the conveyancing. It's almost like a garnishee order, if you want to put it like that, saying, please, in the meantime, keep this money there because the guy refuses to pay me. Keep the money on trust and give it to the attorney. Depends on the amount. So if the damages are worth 100,000, it's definitely worth sending a letter off now demanding performance. So exactly what Silna said, send the letter of demand off. Claim specific performance, but don't necessarily stall the transfer because of it. Go to court on asking for an order, allowing the money to be retained, and then let the transfer go ahead. Transfer goes through, money is retained, and you're allowed to claim your invoice from that money. Whichever way the attorney actually phrased it would be dependent on the actual wording of the contract, but it's just kind of an idea that a person could consider as an option if they were so inclined.
Okay, perfect. Thank you so much. Yeah, I think that answers it in full. All right, and then the next question is, I've always thought the meaning of case struck off the roll means the case was cancelled without a court order. The reason why I'm asking is that I was told the case was struck off the roll, but the applicant got a court order for the same case. Do I miss something here? So I think if we can maybe just briefly discuss if a matter is struck off the roll or if it's postponed sine die or removed, just give a brief description. Bruno.
So very briefly, so the viewers understand, struck off the roll just means that on that specific day, something happened that caused the matter to be removed from the roll. That's effectively what you're looking at. So for example, I've seen many cases where if an attorney doesn't show up, if the advocate doesn't show up, if something's wrong with the papers, it can get removed from the roll. That doesn't impact the actual merits of the case. The case still exists. So the court hasn't made a finding on who is right, who is wrong. The court has simply just said, today's roll consists of these cases. I'm taking this one off because for some reason I don't want to hear it. You get a lot of that with urgent courts, for example, where it gets struck off based on urgency, and that happens a lot in urgent court. Now, so basically, if a matter is postponed, sorry, just to backtrack a second, if the matter is struck off or removed from the roll, an applicant can go and set it down again, right? That court order that strikes it off the roll sometimes even has a little cost element to it, where the person who was at wrong that caused it to be removed might have to pay the cost for that day. But that doesn't deal with the case. The case can still be set down and a court order can still be obtained. And it's very different to the concepts like postponements and things like that, which are self-evident. I mean, those self-explanatory rather. If a case is lost, for example, it's normally referred to as dismissed. And that's what you're looking for. If it's dismissed, they shouldn't technically be able to get a court order. But if it's struck off the roll, it's just a delay.
Okay, perfect. Silna, do you maybe have something to add to that?
Yeah, I think it's, well, that was a very clear answer.
Yes.
You mentioned postponement sine die, which is something that happens quite often as well, where the parties go to court and for some reason the parties will either settle or there's a postponement because the parties attempt to settle, or there was a problem with the service from the sheriff or whatever else. So postponements can happen either sine die or to a specific date. So sine die means to a date to be determined. So when a matter is postponed sine die, it will be postponed, but not to a specific date. And the attorney for the applicant, for the dominus litis, so either the applicant or the plaintiff, will then have to do a notice of set down and serve and file the notice of set down, so the other party again has knowledge and a notice of the specific date. The other party can do it as well, but I won't get overly technical here on civil procedure, but that can be done. Or if it's postponed to a specific date, obviously you don't have to notify the other party, they sort of got the memo. So struck off the roll, unfortunately, doesn't mean anything other than we will see you in court later when it comes to civil litigation.
I don't know if you've experienced this, Silna, but especially with some clients, the distinction that you made just now between postponed sine die and postponed to a specific date, maybe just also to give the viewers a clear understanding, why would we want to postpone to an unspecified date, right? It seems counterintuitive. We keep complaining over and over about how it's so difficult to get court dates and how the dates are so far in advance. Why would we want to postpone it if we, to an unspecified date and go get it later. And I think that's such an important, quick discussion to have, because people question that and they don't realize, for example, in situations where you can't, especially in trials, where you can't get it back on the roll until you've completed certain tasks. And you can only get a date once you've completed certain tasks. So there are logical reasons. I don't know if you've experienced questions like that from your clients.
Definitely, especially for instance, say you have an unopposed eviction. So let's talk evictions, because that's sort of what we do, hey? So say you have an unopposed eviction on the roll for a specific date. If the matter then suddenly becomes opposed, always the day before or in court, suddenly the matter becomes opposed. Usually my clients seem so surprised. They're like, but they are out of time. How can the court allow this? The courts are very big on the whole Audi ultra partem rule. Everybody has to have an opportunity to bring their story to court. Yes, it's outside of the court rules, but at the same time, it's in the interest of justice to have all the parties heard. So in that situation, the court, there's no way the court can postpone to a specific matter. It has to be postponed sine die, because there's a whole process that has to be followed first. And you can only get a date, like Bruno said, after he said a few tasks. It was such a nice way of saying it. You need to jump through a million hoops to get to a point where you get a court date. So exactly, you need to file your heads of argument. You need to do all these things. So it could take quite a bit of time to get to a position where you can get a court date and then enroll your matter on that particular date.
Okay, perfect. Thank you so much for clarifying that. Then we have one question left. He says, my tenant moved in 1 March 2020, a month before lockdown. She paid rent properly for 2 months. On May the 20th, during hard lockdown, she did not pay rent. She started giving excuses about effects of lockdown and salary not received from her. I really tried by all means to be fair and reasonable to her. Firstly, I gave her a 50% discount for May rent. On June, we have signed an acknowledgement of debt for her to settle the outstanding debt within a period of 6 months, but she didn't honor this payment arrangement. End of July, I gave her 20 days final letter of demand. Still, she did not respond or pay rent. The end of August, I decided to give her a 30-day notice to vacate the premises. I also made her to sign agreement to vacate. She accepted everything without a problem. My problem is that I suspect that she might attempt to stay even after the notice. She is already showing the signs of a person who is not prepared to move. In case she can decide to give me a hard time and stay after the notice, what action should I take to remove her immediately from the property? I think if we can quickly just discuss the eviction process, and that we need a court order actually to evict someone, and it can't happen immediately. Silna, do you want to maybe start with that one?
Oh, yes. I'm getting all the fun questions today. Thank you, Madeline. Yes, so I'm so sorry about this, and to hear questions like this, because I think this is unfortunately what we currently seeing every single day, the whole time. So very, very nice from the landlord to give the reduced rental payments, and seriously, kudos to you for trying to assist this tenant. At the same time, I'm really sorry that despite everything you've done for this tenant is still not paying rent and still not coming to the party. So I'm really sorry about that. Only problem that you have is, even though everything was done in writing, there was a cancellation agreement, an agreement to vacate, the entire thing. Unfortunately, Bruno and I obviously don't have sight of that. So the content of the actual agreement is very, very, very relevant. And the way it's phrased is very important. It's one of those things that I would always recommend a specialist attorney do for you, especially when it comes to an eviction, because the content of that agreement is absolutely crucial. But be that as it may, even if one of us drafts it and it's drafted 100% accurate in law, if that tenant doesn't comply with the agreement to vacate, still the only option to get rid of that tenant is to obtain a court order. That has nothing to do with lockdown regulations. It has nothing to do with anything other than Section 26 of our Constitution. Constitution says that no person may be evicted without a court order. So if somebody doesn't vacate willingly, the only way of getting rid of them is by obtaining a court order. Anything other than that, a lockout, taking the front door off to do renovations, guys, that's spoliation. It's illegal in every way. It's not a good excuse. Just because you have a creative solution doesn't make it legal, but I mean, clever and yay, but it's still illegal. Disconnecting utility supply, moving other people in with them, all of these things are illegal, to the point where the unfair regulations to the Rental Housing Act specifically says that this is a criminal offense. And even without the Rental Housing Amendment Act being promulgated, even with that, this is already a criminal offense. So stay away from that, because you don't really want to do something creative and then end up spending a night in jail. The truth is, we're all too pretty for jail. So try to avoid that. Also, I think, Bruno, you and I, neither one of us are strong on the criminal side of life, so we won't even be able to bail you out. So, so stay away from those things. Unfortunately, the only way of getting rid of that person is if they don't vacate on the date that you've agreed to vacate, we have to initiate eviction proceedings. So for that part of the conversation, I'll throw the ball to you, Bruno. But I think I've scared everybody with jail time now, so you can run with the rest.
So yeah, everything, you pretty much covered most of the stuff when it comes to the need for the eviction. So I think what I'll quickly just touch on, maybe just as a warning to most people. So unfortunately with this view, it's been done. We can't go back on it. So there's still advice applies. Don't do anything that you're going to regret later, because it can backfire. From my side, just to anyone thinking about doing something when it comes to entering into payment arrangements and entering into arrangements to vacate, two very important things. So bear in mind, when it comes to payment arrangements, what I normally suggest people do is don't just give a discount. If you're going to give a discount, but only if the person actually pays on time. The reason for this is you don't want to waive the debt, and now the person starts defaulting on the reduced debt, and you're only entitled to claim the reduced debt. So that's very important, because I've noticed some agreements going around where it's not done like this, and it's a bit of a problem. So you want to be able to still claim the higher amount in the event of failure. The second issue, and Still and I have discussed this to death, agreements to vacate, right? So the problem is an agreement to vacate doesn't really make your eviction all that much stronger, right? Yes, there is a level of concession and acknowledgement. So maybe on the merits side, if there is ever any dispute of breach, this is a nice way to approach the eviction, but it doesn't make it any faster. Let's maybe put it like that. So if you go and agree and give the person a month, you're waiting out that month. And when the eviction process comes in, you're starting. So what I normally tell my clients is you need to weigh up your risk. If you're willing to wait for a month, cool. 2 months, it starts getting a bit long. My suggestion then is start the eviction steps. And let's go to court to make this an order of court. So let's treat it like an eviction, but an eviction by agreement where the person acknowledges, an order gets taken. And even if we can't get to court before the date to vacate, the nice thing is we're closer to getting to court. So even if it's a week or two after they were supposed to vacate and they didn't leave, you're still in court. You can still get an order confirmed and go and execute when possible. Now, obviously, there's a lot to discuss around this area, whether you can execute, what a judge would want to see or a magistrate would want to see. But the simple fact is, an agreement to vacate, be very careful. The more time you get, the harder your life is going to be, in the sense that you're going to just need to wait for longer. Maybe start the process. Approach an attorney before doing something like that, just so we can initiate something and get the ball rolling.
I agree 100%. And I think that's sort of on the back of our conversation of last week or the week before that. It's so crucial to do it the right way. I so often see clients finding a solution and trying to save a month here or there, and eventually that ends up costing them a much longer time than just 1 month delay on an eviction. So I agree. I think that's a very important point that I just wanted to echo.
Okay, perfect. Thank you so much, guys. And that is about the time and questions we have for today. So thank you so much for joining me. And then Solna, have a wonderful birthday tomorrow.
Enjoy.
And enjoy your leave. And then Bruno, we'll probably see next week again.
Yeah, we will.
All
We'll
right.
hold the fort while
Yes.
you're on the beach somewhere.
Oh, thank you guys. I appreciate that. And thank you again for my birthday wishes. I really appreciate it. And I'll see you in 2 weeks' time.
And just look out for Silna's comments next week, Wednesday, as we're doing the webinar, and she's got something to say.
Yes.
It's going to be there. We're going to
Exactly.
give a
I'm
nice
gonna
little
watch it.
surprise.
Exactly. I'm going to be that person posting questions.
As long as you don't criticize what I'm wearing, it's okay.
I will never. As long as you don't say anything about another cold front coming, I'll be nice to you. I promise.
No, I don't know.
All right, but thank you guys and enjoy the rest of your day.
Cool. You too.
Thank
Bye,
you
guys.
too.
Cheers.
Bye.
Bye bye.